Good evening, everyone, and welcome to this session that we've entitled Wills on Probate. It's a session that's been facilitated by us, the Watford African Caribbean Association. So my name is Clive Saunders. I'm the chair of the association, and this activity is part of a range of activity that we have been doing as part of our what we call our Black History program. And of course, this is not necessarily about history, but it is about the issues that are important to us as a community. And as we have a community that is aging, it's we all know, fairly sure we're all aware of people not living forever. So tonight we are joined by Mr. Charles Gray, who is a local solicitor who is going to share his knowledge and experience with us, and he'll be able to take some questions that you might have. So if you're not familiar with Zoom, there is an option for you to either raise your hand, or you can also there's a question mark here where you can actually put your questions in, and Charles will pick up those questions once he's made his initial presentation. So we hope you have lots of questions that you want to ask, and hopefully we'll get some answers, so we can all leave here better informed about wills and probate than we might have been otherwise. So thank you all again for coming. I'm going to hand you straight over to Charles. Charles, welcome, and thank you for joining us.
You're welcome. Good evening, everyone.
Good evening.
First of all, I'd like to ask you lot a question, which is how many of you have not made a will? Put your hand up if you've not made a will.
We won't see your hand if your camera isn't on, but you can also put some in the chat if you wish to.
Right. They could put it in the chat.
I see one hand. So if you put your hand up, even if you, so I can see one hand of somebody saying that, I presume saying that they have not made a will as yet.
Right. Now,
Hands.
Right. There is no legal obligation on anyone to make a will, and you are perfectly entitled to die what's called intestate. That is to say, without having left a testamentary disposition. And if you do not make a will and you die intestate, then the law steps in, a statute called the Administration of Estates Act, steps in and lays down the rules for the division of your estate amongst those who are deserving. First of all, that begins an assumption that your family are deserving. And the rules apply differently as to whether you're married or unmarried, as to whether you have children or not, as to whether the value of the estate exceeds certain sums. And it's all laid down. The money won't go anywhere but to your family. And you may have heard talk of it going to the Crown or to the government. Well, it does ultimately, if there's absolutely no one in the world to whom you're connected by blood, but the state don't want your money. It's one of those rare occasions where the Crown does not want your money. It will try its very best to find someone who is entitled through the family to have the part of the estate or all of the estate, depending what the relationship is. And I did have a case about 25 or 30 years ago where a chap in Bushy died, leaving no immediate relatives that were known to us. So we instructed a firm of genealogists. You may have seen them on television. These are the people who they call treasure hunters. And they go off and research all the genealogical records and try to find someone who is entitled to the estate. In this particular case, they found some half-cousins who lived in Tasmania and had never heard of this chap who lived in Bushy. They had no idea he existed, but he was relatively wealthy, and they all inherited a fairly handsome sum of money from someone they did not even know existed, far less even knew. So if you want people that you know or love and trust or want to support, then you should make a will. Because you think of a will, or people tend to think of a will as a piece of paper, a document. What a will actually is, and what the word will comes from, it is an expression of your will, what you want to happen, what you are willing to happen after your death. And therefore, it's a way, if nothing else, of taking control of your life even after death, because you've said what you want to happen. The cost of making a will typically is anywhere between £300 and £500. It can be as low. My firm starts at £280 for really straightforward wills. And sometimes people say, well, I don't have very much money. I've only got my 2 children, and I want it all to go to them. Well, in that case, I can reasonably say you don't need to make a will. If your estate is less than £200,000 and you have 2 children and you want it to go to them, and if you die when those 2 children are still alive, that's fine. And if one of your children were to die before you without having made a will, then the share that deceased child would have taken would pass to any children they have. So there is a machinery for getting the money distributed. But the will makes sure that you design the machinery. It's your piece of machinery. You say what wants to happen. You don't leave it up to the statute. So my recommendation is make a will. Sometimes the results of not making a will can be truly catastrophic. I'll give you just one example. Relatively recently, 5 years ago, here at this office, a woman came into my office, never met her before, didn't know her. She explained that her partner of some 25 years had gone to work the previous month, a man of 53, a plumber, and during the course of working on a job in London, he had a sudden heart attack and died. She and her partner were not married, as I've said. They did own a house together. They had 2 children, a boy of 18, just about to go to university, and a girl of 14. Now, because there was no will, there was no provision for this lady. She's not married to the man. She's not got any rights under the Administration of Justice and the Administration of Estates Act. All she has is a right to make a claim against his estate under the Inheritance Provision for Family and Dependents Act. So she essentially has to make a claim against the deceased partner's estate. The only person who is eligible to be the administrator of the estate is her 18-year-old son. So she is essentially making a claim against her son for provision out of her partner's estate. The 14-year-old girl, still at school obviously, because she's only 14, she cannot agree to anything. She has no legal capacity to agree. So someone else has to be appointed to act for her. Now, in all of this, obviously the family wanted to cooperate and were able to cooperate and get the best for everyone, but it ended up with 3 separate lawyers instructed. I'm acting for the son as the administrator of the estate, another firm in Watford acting for the woman, the partner of the deceased, making a claim under the Inheritance Act. And because the 14-year-old girl cannot represent herself or make her wishes known, she has to appoint a solicitor to represent her. It ended up taking nearly 3 years and costing over £35,000 in legal costs for a modest estate. The estate altogether was about £220,000. So had he made a will, all of that would have been avoided. If he'd simply made a will leaving part of it, simply leave a will saying what he wanted to happen, it would have been enough. But had he made a will leaving his estate to his partner, who'd been with him longer than many people are married. I also do divorce law, and a lot of people don't stay married 23 years. All of that would have been avoided. All that cost, all that stress, all that pain added on top of the bereavement. So that's a good example of why you should make a will. Now, I saw someone put a little note up saying, I have made a will but needs updating. Very simply done. Write out on a piece of paper what the updates are. Go and see a solicitor. Tell him what updates you need to make. He may even tell you you don't need to update that, because it might be something as a change of address or a change of name because one of your children has got married and now uses a different name. You don't need to change your will for that. Absolutely not. Keep the money in your pocket. But it is a good idea to review your will every 5 years or so. I don't mean change it. I don't mean rewrite it. I mean review it. Look at it to see whether it still does what you want it to do. Right? I've just had a question here. Could they have agreed what would happen between them? Well, yes, they did agree, but they still had to go through the legal processes because the son, who's the administrator, can't just give the money away to his mum because his sister's got entitlements as well. The mother can't agree just to share it between the two children because she's got to live. She's got to get the house in which she is living with the children. So it was done with a great deal of cooperation, but it still needed that three-ring circus of lawyers to make it all legal and get court orders for it all to work. Right? So updating your will is usually, or should be, relatively easy. You should never, if you have the original will, never write anything on it. Write your notes separately. Then go and see a solicitor, tell him what updates you want to make, and he will talk you through it. Right. Are there any specific questions about what I've said so far?
I have one quick question. It's Marilyn here. I was just typing it in the chat, but as you're asking, do the DIY wills from W.H. Smith's, I've seen them on the shelves. Are they a starting point where somebody maybe isn't yet in a position to go and get it done the official way that you are talking about?
Right. They're not meant to be a starting point. They're meant to be the template for you writing your will. And that would be a rather expensive starting point. All you need is a starting point, is a pen or even a pencil and a blank piece of paper, quite literally. You just need to write out what you want to happen. Now, if you're writing your own will on a W.H. Smith forum or forums that you can get online or on just a piece of paper, as I say, there are certain things to watch out for, because the way a will is written can often lead to ambiguity, and ambiguity leads to failure of a will in many cases. The other danger of making your own will is you have to be sure that you observe the provisions of the Wills Act, 1837. 1837, that's the last time the wills, the way wills were made, were reviewed and changed in law. So we're getting on for 200 years and they've not changed how a will has to be made. It is essential that the person making the will, the person us lawyers call the testator, let's say the will maker, it's essential that that person's signature to the will is witnessed by two independent witnesses who are present at the same time with the testator and who sign the will, adding their name, address, and occupation. The name, address, and occupation are not legal essentials, but they make it much easier to contact a witness in the event of there being any suggestion that the will was not properly witnessed or that the signatures are forged. So the absolute requirement of a will is that it must be properly witnessed in accordance with what I've just said. The person signing the will must be with two witnesses, all three present at the same time, all appending their signatures, and preferably also, in the case of the witnesses, appending their names, address, and occupation. Makes them easier to find. And I've had examples of that here where we had a will which was not properly written out, but had been witnessed by two neighbours who still so happened lived in the house next door. And luckily, one of them kept a diary of her signing the will about 30 years previously, when they'd been invited in for dinner to the neighbours so they could have dinner and witness the will. So we were able to say, you get a statement from that lady saying, yes, my sister and I witnessed this will. I remember the circumstances, and the will was then proven. We could go take that to court. But if you don't do that right, then your will can be a useless piece of paper. The other thing I mentioned about ambiguity, it is quite easy to phrase your will wrongly. If it's very simple, saying, I'm appointing my son, John Smith, to be the executor of the will, and I'm leaving my entire estate to be divided equally between John, Peter, Alex, and Brenda. And it's provided that's properly signed, perfect, perfectly good will. But it can get more complex if you ask yourself this question. What happens if one of those children die? What if Brenda dies? What happens to her share? Do you wish it to go somewhere else, i.e. to her children? Or do you want it to fall into the estate so it's divided up amongst the surviving 3 children? Or do you want it to go to a charity? Or do you want it to go to some other person? And it's when you get these slightly more varied, and that's not an unusual variation, that you do have to be careful about how you write that out. There is millions of cases, well, millions, many thousands of cases over the last 200 years where wills have been challenged for one reason or another. And those challenges have grown since the early 70s when they brought in the Inheritance Act, which allowed people who were not mentioned in the will, but who should have been mentioned in the will or think they should have been mentioned, to make a claim against the deceased person's estate. So the simpler and the most clearly expressed will is something you really should strive for. And it is worthwhile taking legal advice on that if it is not as simple as what I've said. I'm leaving it all to my 4 children and I want John to be the executor. That would be a perfectly valid will, provided it was properly witnessed. So to answer the question about your W.H. Smith forms, yes, you can get them, you can use them, but they needn't be a starting point. Because if you spoil it and you've not written it all clearly, you've got to go and buy another one. So have it all written out on a piece of paper beforehand. Be very clear about what you wish to express. Then you can fill in the W.H. Smith form. Frankly, as a lawyer, I love them because there's more mistakes made in them that end up on my desk, and I've got a bill to present for £10,000.
Jenny, I think wanted to ask a question on this.
Yeah, I would like to ask a question. You talked about a mother with so many children, and if there's no will and the mother has 3 children and one of the children dies, where would that money go? Would it go to
the surviving children?
Would it go to his children?
No, it would go, we say his children, right. If the person who dies and they too have children,
yes,
then it would go to those grandchildren. Yes.
Oh, right. Okay.
But if there were no children, it would fall into the residue of the estate and be divided amongst the surviving children.
Right. Okay.
So let's say, by example, there's 3 children.
Yeah.
All of them have 2 children each. One of them dies. The person who's died share would go to the surviving children. His surviving.
The grandchildren. Yeah, the grandchildren. Yeah.
Yeah.
Okay. Thank you.
And that's under the rules of intestacy and as expressed in the majority of wills, which I do as well.
Right. Okay.
Charles, just a slight follow-up to that then. If when a will was made, one of the children had already died,
yeah,
would that make any difference?
Well, just that there'd be no provision in the will for the person who's already died, because you would not be leaving anything to anyone who was already dead.
Yeah, okay.
You would make the provision for those who you felt should benefit who had survived him.
All right. So if they had children, you could make provision for the grandchildren.
The will is made at a point in time, but it doesn't come into effect, as I was saying earlier, until you're dead.
Mm-hmm.
So that point I was making about reviewing wills is very important, because you may make a will when you're in your early 30s, you've just bought a house, you've got your first 2 children, you make provision for them and you appoint guardians for them in the event of your dying before you reach the age of 18. And then in intervening years, much may change. So that's why you should always be conscious of looking at your will. As I say, every couple of years, take it out and say, does this still work? If it still works, put it away again.
Okay. I said Valerie had her hand up. She's taking it down. I don't know if she is having a problem with her hand.
No.
Or what?
It was by mistake. I have got a question.
She's waving a fist at me.
I recently I recently read an article which I found quite difficult, and it was that a guy had his died, and so he inherited everything, and then he remarried, and after he died. Now he had just, well, I think that's what he did. The house that he had his first wife would go to the son, his son.
Yes.
His, but his new wife. No, he died, and then his new wife.
Valerie, do you want to take a camera?
To her.
Valerie, do you want to take a camera off, because you're breaking up? Maybe just leave your camera off and see if it's better.
Okay, crack on.
Yeah, like that.
Yeah, try that.
Okay, yeah. So the husband had died. So then there was just the new wife, let's say, and she started to change his will. So the house which he left to his son, went to her, and apparently he didn't even know that he had left everything to her son. So I just wondered, how can that be? If husband had done this shared will, that she could change it.
Right. I think what you might be driving at is this. Sometimes people make wills which are called mirror image wills. A married couple will come in, and this happens quite often, leaving everything to each other in the first instance, and then when they're both dead, leaving it on to their children, and if any of the children die, then on to the grandchildren. That's a fairly standard mirror image will. Now, what a solicitor should do on those occasions, and what I always do, is I ask whether they want these wills to be simply mirror wills, or whether they are to be irrevocable mirror wills. Now, you can make your will irrevocable by agreement with your spouse or the other person with whom you're making a will. You say, we promise we make these wills, and if one of us dies, we will not change them. That is a mutual and irrevocable will. They're rather rare because they can be very dangerous. Because if you make the mirror image will and it's irrevocable, you cannot change it after the death of the other person who's made the will, usually your spouse. But there may be good reason to change it. Right? But what in this case, I think what you're describing is that there was a mirror image irrevocable will which was challenged. But I'm not quite clear from what you've said, because you were breaking up a bit, that I've understood that correctly. Now, you can challenge an irrevocable will, but it's very difficult to do so, because you've made a solemn agreement with the other person that you won't change it after their death. So you would need to have very good reason.
I don't.
Valerie, do you want to put it in chat if you
from
can?
what I
Because,
read, I don't.
You're breaking up every time you try to speak. You're breaking up for some reason. Something with your connection.
Yeah, I don't think it was revocable.
Right. Well,
maybe he just didn't realize that he could change it.
Okay.
Well, they can change. You can change your will whenever you like, unless you've made that agreement to make it irrevocable with another person. So your will is changeable at any time up until you die.
So Charles, I imagine from what she's saying there that they made a mirror image will, but it wasn't irrevocable. So consequently, when this person died, the person who remained changed the will then to
having inherited.
Yes.
Well, that's common enough. And then they fall out with the son.
Yes.
And then they change it and give it to their children rather than the children of their spouse. That happens quite often in second and third marriages, where you have family dynamics which are often very, very fraught.
Okay. Does that deal with your point, Valerie?
Thank you. It does. I was just confused as to how she could change the will. But yeah.
So could someone challenge that if something like that, is that something that could be challenged?
They may not be able to challenge the will, but they may be able to challenge under the Inheritance for Family and Provisions Act. They may be able to challenge it as being a person for whom provision should have been made. The most typical example of that I've seen is a couple who have been married both for the second time, leave everything to each other. One of them dies. The surviving spouse, who perhaps never liked one of the children from her previous marriage, or falls out with one of them, changes his will to disinherit that child. Now, the thing is, that's his estate. He's already inherited it from his wife. So the son or the disinherited child could launch a challenge under the Inheritance Act as a stepson, saying, I should have been provided for in his will, and show the fact that I was provided for in my mum's will, but he's deliberately disinherited me. I've not come across such a challenge, but it is a challenge I believe could be made.
Okay. So my question to you on that then, Charles, was how likely would that be to be successful? I can see the rationale for it, but is that likely?
Right. It would depend on the circumstances of the person who's making the claim. Let's say that disinherited son was in difficult financial circumstances with lots of financial commitments and needed the money badly and could demonstrate he needed the money badly, and that he was to an extent dependent upon his late parent who had helped him out or had led him to believe that when she died or he died, he'd be getting some capital monies to make his life easier. Because the inheritance tax looks at the strength not only of the claim as to relationships between the parties, but also as to the need for making the claim.
Okay.
So if the disinherited son was himself comfortably off, owned a home with a modest mortgage or a standard mortgage, had a good job, had some savings in the bank, then it would be harder for him to say, I really need this money. And the way the inheritance tax works, it's a bit like how divorce law works. When the court is dividing up money in divorce cases, it's one of the questions asked is the need demonstrable? But yes, if he came through my door, I would certainly consider his circumstances very closely and then advise him on his chances of success with a view. And I'd also want to find out how much was in the will, how much is in the estate. Are you going to spend £20,000 to get 10? You're going to spend £50,000 to get 25. There's that risk as well.
Yeah, just a variation on that, Charles. So I've heard it said that if you made a will, and for example, you have children, and you left one of the children out of your will without even a penny, then that child would have a legitimate reason for challenging the will.
Yes,
whereas if you left the child with a penny, then it shows that it was a considered decision by you to just give him a penny as opposed to anything else. Do you know anything on that?
I see what you're driving at. If you leave them only a penny, they've got nothing to lose. Okay? Yeah. This arises out of a case some 10 years ago called Eilert and Meissen, where a woman who had made her will excluding her only daughter, her only child, from all provision of the will. She'd left it all to charities. There was a long history of animosity between mother and child. The child, her daughter, had married a man who the mother did not like, would not countenance, and she wrote her daughter out of the will. It was entirely considered. It was entirely considered. She was told by the solicitor at the time, and that was evidenced, that the daughter could make a claim against your estate because she's your only daughter. She said, I don't care. I'm not leaving her anything. There was an attempt at a reconciliation between the lady and her daughter, but it didn't take. She remade the will subsequently, changing one of the charities who were to benefit, but still saying, I'm leaving nothing to my daughter. We've been estranged for many years. I don't want her to benefit under my will. Could have been more clear, could have been more considered. The lady then died and her daughter made a claim, and she was opposed by the charities on the basis that her mother had made it perfectly clear she was making no provision. The estate was worth about £250,000. It was all used up in legal fees. But the charities fought it to make a point. The point was, if you make a will, it's your will, that's what you should happen. This woman didn't forget to provide for her child. She said, I'm deliberately deciding I will not provide for her. The daughter's case succeeded. But all the money was spent anyway. And it succeeded because of the point I made earlier. She was in dire need. She had 4 children. She was no longer able to work, but she'd always worked in low-paid manual jobs. Her husband, the man that the mother-in-law didn't like, worked in a low-paid manual job. They were claiming universal benefits to supplement their income, and they were on housing benefit to supplement their income. And the court took the view that this was a case where there was need and there was money to fulfill that need, and she should have an award. And it went all the way to the Court of Appeal, which is where all the money went. But the decision that had been made at the very first court, the local county court, which was she should have, I can't remember what the award was originally reinstated. It went to county court, then appealed, the amount was changed, went to the appeal court, and it was put back to what it was in the first place. But she did succeed in getting something out of the mother's estate. So after that, guidance was put out to solicitors, not formally, just amongst solicitors, that it's a good idea to leave a big enough legacy in the will to the daughter or the child or the person you don't want to benefit, to put it at risk if they challenge the will. The clause would say, I'm leaving her £20,000, but if she challenges the will, she loses this legacy. So a penny wouldn't do it. To answer your question, Clyde.
Okay.
Not that it's not been considered, is to make it not worth the risk of the disappointed beneficiary claiming, because they might lose more than they would ever gain. But you need to leave them a fairly substantial legacy to make that scheme work, if it works at all. I've done that 2 or 3 times.
Okay.
But so far, none of them have died yet that I know of.
Somebody just asked for your
yes, I saw that.
and I've just put it in the chat, Charles. Okay. Did anyone else? Did you want to take any other questions on wills before we move on to probate?
I think I've answered all the questions I've been asked. Happy with that.
Well, just on a slightly different issue, because
I think Valerie's waving again.
Valerie?
I'll just get rid of my picture then. Sorry. Yes, I do have another, and it is to do with wills. If I can, if you no, can you leave your inheritance to your child, to a child? If say you've split or something with the with your partner,
yeah,
can you, and something happens to you, can you leave your inheritance to your young child?
You can leave your inheritance to whoever you wish. That's the main thing to remember. It is your will. You can leave it to whoever you wish. You can favor one child over the other for various reasons, because you like them better or because you think they'll need the money more. Anything of that, the decision is entirely yours. But it can be open to challenge by the children who have not been provided for, depending on the circumstances. But remember, they're not challenging the will. You can only challenge the will on 3 grounds: that it's been invalidly made, that there's been undue influence or duress. The case I was talking about, Islet and Myson, where the daughter made a claim against the estate of her mother, despite 40 years of estrangement, she won. That was launched under the Inheritance Act. And that's for people who feel that they should have been provided for in the will and were not.
So that could be, say, the mother of the child, if only the child's, a young child, say under 10, has been left everything in the will, and nothing was left to the mother, say, who would probably have to look after the child. Could that be disputed?
The mother can make a claim under the Inheritance Act.
Sorry, what was that?
The mother can make a claim under the Inheritance Act. That was exactly the situation I outlined in the case I was talking about that ended up with lawyers' fees of 35,000. He didn't leave anything to anyone in the will, but had he left it to the children, then the mother would have still had to make a claim under the Inheritance Act, because, as you rightly point out, she would have to look after the children. She would have to house the children.
Okay. Angela wanted to come in. Angela Wells.
Hi, good evening. May I just ask you, in the case where the property has been made tenants in common by the partner, what happens in the case if the one of them who have left their inheritance to someone?
If you're tenants in common, the characteristic of a tenancy in common is that each of you own a defined share in the property which you hold as tenants in common. Typically, it's usually 50-50. If the person who has died has left their estate or their interest in the property to someone other than their co-proprietor, it passes to the person to whom they left it.
Thank you.
Okay. Another word on that, though. Tenancy in common, whereas is what we call a severable interest. You can also hold a property as joint tenants. If you're co-owners as joint tenants, on the death of either one of you, the survivor automatically inherits the whole of the property.
Thank you.
So that is something you might want to check, because it can be very much a live issue. And unfortunately, you can't quite check it on your title deeds, because in modern title deeds and registered land, they don't use those terms anymore. Those were terms used under the old conveyancing law. a tenancy in common is now shown in the register with a little note called a restriction. And the restriction says the survivor of the tenants in common cannot give a receipt for monies received for the sale of the property. It means there needs to be another trustee appointed if it's a tenancy in common. Whereas if it's a joint tenancy, that restriction doesn't appear. And that was all you would know. You'd never know by looking at it unless you're a lawyer.
Okay, thank you.
It's interesting, Charles, as you say that, because as it happens, I know somebody who's got a painful experience of that particular situation, because there was a couple who were not married and they were joint tenants in the property that they own. They both had their own children, and the gentleman died, and of course the property passed to the partner, who, as it happened, didn't get on with his child, and that child is demanding part of the estate, but of course the estate belongs entirely to the surviving partner.
It does, yeah, and there's just no argument about that. The person claiming is never going to win. It's not even done under the will. It's done under what's called the jus accrescendi, which is, the law says that if you're joint tenants and one of you dies, the other tenant automatically inherits the whole of the property, and that's the end of it.
Just a further question on tenants in common then. If you are tenants in common, and say in my case, and I was to, my partner was to die, we're married. Now, of course, she would have made her will defining what she wants to do, where the benefit needs to go. But of course, I have a right to stay in the property until I die. How is the actual proportion determined if I die only 10 years later, as opposed to, how did I work that out?
It's still 50-50.
So if a property was worth 100,000 now, 200,000 in 10 years, then it's be 100,000 in 10 years as opposed to 50.
It's always half. The proportion is always half.
Oh, right.
Unless the rest is some other percentage. But for two people who own a house as tenants in common, unless there is a declaration saying that the percentage is different from 50-50, it's assumed to be 50-50.
So in short, if the price of the property went down, the proportion will go down. If it go up, it will go up in cash terms.
Yes, that's right.
I think, I'm not sure what your name is, but on Ogun Sakin.
Yeah, sorry, I should have put Annette.
Okay.
Probably one or two questions that might come in, but initially, I've got an issue. It's not an issue, but because I'm recently separated or divorced, but I was going to need to make a will, and my daughter's under 18, and I might need a guardian because she's under 18. So that's an issue that's coming up. Whether to wait until she's 18, she's 17.
The first thing to say is that the person who would have the strongest right to be appointed or guardian would be her father.
And if you're separated?
No, I'm divorced now.
Right. Does the child see her father?
Not recently, no.
Not recently, right. So in the event of your dying without having appointed a guardian, the person that to be looked to, as it were, would be the father. And he has the first legal right to step in and look after the child, should you want to do so. Even if in your will you appointed someone else as the guardian, then he could challenge that. And if the challenge was real, it would be decided on by the court under what's called wardship proceedings. The child would be made a ward of court. The child would almost certainly remain where they were for the time being, whilst the court decided what was in the child's best interests, to stay with the appointed guardian under the terms of the will, or to go to her dad, or even to go to some other party, depending on what the circumstances were.
Mm.
But if you want to appoint someone as your daughter's guardian in the will, it is essential you do so, because without it, once again, you have not expressed your will.
Yeah,
you must say what you want to happen. Whether or not it can happen is a different thing, but you must say what you want to happen. That is an essential.
Okay, does that answer your question?
Yes, it does.
Thank you.
Charles, further question that I'd ask you before we leave wills. How important is it that you have a solicitor to execute your will, as it were?
Well, I would say this, wouldn't I? I think it is not essential, but it is very, very, very advisable. And it is really not that expensive. If you think back to the case I outlined with the £35,000 worth of legal costs, if that chap and his partner had come to see me to make their wills, it would have cost them about £700 at the very most. Right? Okay. That's what we're looking at. You're looking at huge magnitudes of difference in legal costs if you do not make a will and there are challenges as to how your estate is dealt with. And it's so easy to do.
So if you have made a will, what determines the legal cost that you then incur?
What you ideally, your will, if it's well made and circumstances have been kept up with, the cost of making the will is always going to be around £300 to £500. Okay. The cost of not making a will and something going wrong is indeterminable, because it depends on what it is that's gone wrong. And it's just easier to get it wrong if you don't use the right terminology. And the solicitor is more likely to use the right terminology. And if he doesn't, you can sue the bugger.
Sir Charles, clearly I'm not getting my terminology right. I meant you've made a will.
Yep.
You've died. You need then to sort the estate out. What's the kind of cost that's involved?
Oh, right. I misunderstood your question. Okay. It would depend on what the complexity of the estate was. My own costs, and I'm doing them in this office, we're doing them all the time. In the last, let's say since the beginning of the year, I've estimated costs probably on 10 or 12 estates, and they will range from £1,000 to £1,500 up to £7,000, and in one case up to £18,000. The £18,000 was a man who was extremely rich and had assets, lots of assets in this country and assets in Spain. And that's going to be complex. The one at £1,200 and £1,500 is a chap who's leaving, he's died, he's left everything to his wife who lives in the same house. The house will be going to him. They've got mostly joint accounts, but he's got several ISAs in his name. And he's got, you don't even remember the old Tessa savings scheme, which was unearthed. And that is going to cost, I've budgeted it for £1,200. It's probably not going to cost that much. So it depends on what the extent of the estate is. If you die very rich and with complex monies all over different jurisdictions, it can be very expensive. One which is common enough, and this is important, this is quite important for your community, quite often I have people who still own land in the West Indies or own land in the Americas. In the Irish community, which I've also quite a lot of Irish people, lots of them still have land in Ireland or interests in land in Ireland. And that can be quite expensive to sort out as well. The other one I get occasionally, actually quite often, is people who own land in Spain or own a flat in Spain, which they've had as a holiday flat, and that's got to be disposed of, and that can be quite expensive.
Okay.
The simpler you keep your affairs, the better. Sometimes you don't need a grant of probate at all.
Okay.
If the person who dies has got the house in joint names as joint tenants and have all their accounts in joint names, there's no need for a probate. You don't need one at all.
Ah, right. Okay, we'll say a bit more about that, but just there are some questions here, just going down the list. Do you deal with trust wills is the first one that I come to.
Yes, I think I know what you mean, but essentially all wills are trusts. But trust wills, I take it you mean leaving the estate in trust for people who are not yet of full age or who may be in some ways disadvantaged and they can't manage their own money. Yes, we do all of that. We would be able to give you a full...
My understanding, Charles, and I may be wrong, is that if your estate is above a certain amount, there may be some advantages in setting up a trust for tax purposes. I'm not too sure whether that is or isn't the case.
There can be, but I must say, now the tax rate for people who own a property and are leaving the property to their children, their nil rate band, before they pay tax, their estate has to be worth £1 million.
Oh.
Now, that's becoming quite common here. There are lots of people in Bushy, particularly, who've become what I call accidentally rich.
Okay.
They happen to buy a house here 40 years ago or 25 or 30 years ago, and now these houses are worth £1 million.
Okay. Okay, so the 325,000 limit doesn't apply to property.
£325,000 is the basic nil rate band. If you're a married couple and one of you dies, the surviving spouse inherits that nil rate band, so that doubles to 650,000. If you own a house and you've left it to your children, you get the residential nil rate band, relatively new, only came in 3 or 4 years ago, and that's another £175,000 each.
Okay.
Which adds 350,000 to the 650,000. There.
Right, okay. That's good to know.
Yeah.
Okay. There's a.
Can I just say one thing? Most people that come into my office to say they want to make a trust will don't realise that £1 million rate band exists.
Right. Yes, because I didn't know. I didn't realise it either. Okay. So just going down these other questions. If parents are deceased and no known will, is it possible to do a search and find out if there's a will that was made?
Yes, there is. There's 2 ways you can make searches. You can make a search at the Wills Register, which is maintained in London. Personally, I've never done it. There is also a private company called Certainty, who maintain a register of wills. So you can make a search there as well. You can also make an informal search by writing to all the local solicitors, asking whether they're holding a will for Marsha Smith, and they will check their records.
Okay. So if I've got a will, so yes. As it happens with your firm, but if somebody didn't know that, they could go elsewhere and find out. They could go to this other place.
Make sure that the people, it's your job to make sure the people who do need to know do know. You should tell your children. Yeah. Okay. You know, if you have, as I imagine most of you have, you've got a drawer or a box or something at home where you keep all your valuable bits and pieces. A copy of that will should be in there. If it's come from this firm, it will have a firm's name and address, the reference at the bottom of it, so they know who to contact. And they can say to me, are you holding my dad's will? I will go and check in my registers and I will be able to tell them within minutes whether I am or whether I am not.
Okay.
So it's advisable if you made a will to make sure that your children or your executors know that there is a will and where it's to be found.
Okay.
There is no national will register that really works.
Okay.
Okay.
So this sort of question probably is just touching back on this again. When should a trust be considered instead of a will, if you are going to go down that road?
Right. There are lots of different ways of answering that. I'm not a great fan of trusts. Lots of people have entered into wills in which they've entered into trusts and they don't even understand them, and they've never understood them. They read something in the Daily Mail. They got in touch with some firm through the Daily Mail who gave them 72 pages of nonsense, and they've got no clue what it means. The only good reason to put monies into trust is if you have a beneficiary who's underage, or you have a beneficiary who is vulnerable and cannot manage their own money, or if you have a beneficiary who you think is likely to be reckless with money, so you don't want to give them it all in one go and you leave it to trustees to dole it out to them as and when they need. or you've got so much money that you want to put some of it in trust during your lifetime to get rid of it in a different way, creating a lifetime trust.
Mm-hmm.
In this office here in Bushy, I don't see very much need for those type of trusts. Most of my clients are what you would call it ranges from salary levels of 25 to 40,000 pounds up to salary levels of 150. Property levels, owning properties worth 350, 450, 650, 850, £1 million. The £1 million people tend to be older ones. As I said, what I call the accidentally rich. They were usually people who had ordinary jobs, got a mortgage 30 years ago, bought a house in Bushy, and it's because of its position, it's become more valuable just because it's Bushy. And the same applies throughout London. There are people who bought flats in London under the Right to Buy scheme in the 1980s, and these are now worth £1 million. And suddenly they're worrying about their money.
Yes.
There was a question there about a deathbed will.
So we just go down, because this next question is, can you repeat a bit about tenants in common, please? Somebody didn't hear it. And therefore, it also means joint tenant, I suppose. If you could just say a bit more about it again.
The distinction is a tenancy in common is a severable interest in land. You can leave your share to someone other than the other person with whom you own it. For example, it can be tax advantageous, seldom is, to leave your interest in the property on death to your children rather than to your spouse, which I think, Clive, is something you were alluding to.
Yes.
You've got the right to live in the property after your spouse dies, but that half of the property goes to the children rather than to your wife.
Mm-hmm. Yes.
That's a severable interest. You've left your share to somebody other than the wife with whom you own the property. A joint tenancy means that when the first of the two joint owners dies, the survivor inherits it automatically. The whole of the house, the whole of the value of the house goes immediately to the survivor. It cannot be severed. It cannot be left to anyone else unless you sever the joint tenancy. You can convert a joint tenancy into a tenancy in common by serving notice of severance and telling the land registry to put that restriction on the register.
It's interesting.
It's not something you should do until you've been to see a solicitor. Doesn't need to be me. I'm busy enough, but I'd be delighted to see you. But you should see a solicitor about that, because the implications can be very severe if you don't get that right. You think you're doing something which is going to achieve an object, and it might be doing the opposite. Okay?
Sorry, it's interesting you say that, because I must admit I didn't realize that actually the debt benefits also transfers to the surviving spouse. From what you're saying, I thought that that benefit would die with you, but so it remains. So the 625 becomes 650. The 325 becomes 650.
That's if you're married.
If you're married, okay.
You're married, yeah. Okay. Only works if you're married or in a civil partnership. And do remember now, civil partnerships are available to same-sex couples and to opposite-sex couples. You don't need to marry anymore.
Yeah. Excuse me.
Yeah,
sorry, I was going to.
Yes.
I was going to ask, what about if you're? I was going to ask, what about if you're not married and the 1 million?
Work. You have to be married or in a civil partnership.
But in terms of once you have an estate to pass on and you've got 2 children and you're not married, what will happen then in terms of the 325,000 or the £1 million rule?
You only get it once because there's no spouse.
I need to get married again.
Well, wait a moment. You're not losing anything. You get 500,000. You would get your nil rate band plus your residence nil rate band if you own a house and leave it to your children.
Except she's got
extra 500 because you don't have a spouse.
Except she's got an £800,000 property.
Right. Well, then she would have to pay. The estate would have to pay inheritance tax on the £300,000. But it's not worth getting married just to save that.
No, don't want that.
Okay, so next question. What if an executor decided to opt out of being an executor?
Well, they can simply...
executor. So not executor, executor.
They are executing the will. That's why they're called executors. They just pronounce it slightly differently. I did that just last week. I renounced my executorship. On a will, it was relatively simple. The two children said they could do it themselves, but I've been an appointed executor under the will. So I renounced that, and the two children would do it themselves. So an executor can renounce. He doesn't need to take up the appointment.
Okay. So I think there's a probate question, but maybe is deathbed recognized in law? We'll come back to the probate question. I don't know what that means. Is deathbed recognized in law?
It depends what you mean. No, generally speaking, because the Wills Act, remember I said about having to be signed in front of two witnesses, that applies almost universally. There are exceptions. Deathbed wills, provided they are properly witnessed and truly deathbed, are one of the exceptions, but it depends very much on the circumstances. Soldiers' wills are always given some leeway, particularly soldiers who are going into action and may be killed before they get a chance of giving anything very much thought. They too are given exceptional treatment. But it really does have to be exceptional. Now, the other thing about a will is, I was saying earlier, it just needs to be written on a piece of paper. I went to an exhibition up in the Royal Courts of Justice about 20 years ago when my daughter was little, and took her up there, and they had wills which were written on things as various as an egg, and it was a valid will, written on an egg, written, burnt onto a piece of wood, but validly witnessed, and it was a valid will, and a will which, one of the most classic cases of how to interpret a will, a chap had made his will, had it properly signed and witnessed, and he'd said, I leave everything to mum. So who's that? Who's mum? Well, the fact was, he was a man in his 70s. His mum had been dead for 40 years. Mum to him was his wife. Mum was what he knew his wife as and what the family knew his wife as. She was mum. So the court took all the circumstances into account and they said, well, that's his wife. He's left everything to his wife. But that just goes to show what I mean about ambiguity. That had to go to court. If it just written in the will, I'm leaving everything to my wife, no problem.
Okay, Charles, I can't see any more questions relating to the will. Did you want to say anything about probate before I take? There's a couple of questions. Sorry,
yeah, just one last one. Sorry, I'm making use of it.
That's okay.
Yeah, I've got a friend with me, and she just wanted to know if you can leave, as a single person, if you can leave, have two executives, like two children as executives, but because one of them are in a different country, can that be done?
Yes, it can be, but it can be, it's perfectly legal, no problem, but it can be practically awkward. I've got someone in New Zealand at the moment, and every time I send them an email, they've got to send me back an email to say, I've put it in the post, because I'm sending them hard copy documents. 3 weeks later, it arrives. And then I find they haven't signed it properly. I've got to send it back again. So there are practical differences there. But yes, there is no bar on who you appoint. They have to be over the age of 18. And that's all there is to it.
Okay. Any final questions on probate before, on wills before we move on? I can't see any questions. So just any point you want to raise about probate, Charles, before I know there's at least a couple of questions I can see in the chat.
Okay, we'll do the questions first, but I'll tell you first of all what probate means.
Okay.
The word probate is a Latin for proving. It's to prove something, is to probate it, to make it true. So a grant of probate is you send the court the copy of the will or the original will, and they check whether it is valid as to the signatories and check whether there's any challenges to it, because you can challenge a will and you can tell the court beforehand that you're going to challenge it, called a caveat. I won't go into that too much. But the grant of probate is then sent back, and it's a document. These days it's electronic, and it's sent back to you with a little seal on it. But then you get the hard copy, and it's got a little digital disc, which shows it's been proved by the court. That is then sent to anyone who's holding assets of the estate, to banks, building societies, investment houses, stockbrokers, to show that the person named as the executor is now the person entitled to deal with this dead person's affairs. The probate, think of it as, the way I always try and describe this, imagine the dead person's belongings were all in a huge pirate's chest, right, with really big seals on it and great padlocks you could not open. The probate is the key that opens that box, and then you can take out of it everything that belonged to the deceased person and distribute it in accordance with the will. So the executor may not be a beneficiary of the will. They can be. A lot of people think if you're a beneficiary, you can't be an executor. That's wrong. You can be an executor and beneficiary, and often the best executors are beneficiaries because they have an interest in getting it done and getting it done properly. But the executor's job is to gather in the estate and pay it out according to the terms of the will. So as a solicitor, I'm often appointed executor. I gather in the estate, I look at the will and say, 10 people have to get £1,000 each, I send them their £1,000. 5 charities have to get £2,000 each, I send them their £2,000. And then the residue, that's what's left after paying out the legacies and paying off testamentary and funeral expenses, gets divided, let's say, amongst the 4 children in equal shares. So I work out what's left. There's £200,000 left, and each of them gets £50,000. That is the simplest form of probate, and that is generally what happens. Sometimes it can take as little as 2 or 3 months. Sometimes, as in the case of when there's property abroad, or there are complications, or you have difficulty finding assets or establishing the value of assets, the worst thing that can happen to you is if you any investments in American shares which are worth less than £500,000, cash them now, because trying to get money out of the States for assets held in the States is hellish. It takes forever. And you've got to pay Uncle Sam before it comes home. So do be careful.
Okay.
But that's all an executor does, and that's all a probate does. A probate is proving the will, getting the authority of their court to use the probate, producing it to the asset holders. And for example, the land registry, if the house is going to be sold, you have to put a name on the register, or you can sell it as an executor and show the people buying it, solicitor, you've got the grant of probate. It's the authority to deal with the dead person's assets.
Okay.
The dealing with them is just gathering them in, paying them out.
Okay, thanks very much. So you probably answered mostly this question, which was how long does an ordinary probate take, and what does it include? I don't know if you want to say. I think you've answered much of that, but I don't know if you want to add anything more.
Right, well, I would say the average probate, average ordinary probate, is now taking about 6 to 8 months. There was a little period there during COVID and up until about 2 months ago. Unfortunately, COVID impacted the probate registry just as they were implementing a new computer system. So these two things clashed in an unholy alliance, and it was taking ages to get grants of probate. But they're over all that now. So the sequence is this: the person dies. Usually within 3 weeks to a month, the executors will come to see me to say, you're the executor, or we're the executors, but can you do this for us? Depending how well briefed I am from the outset, if they can give me a list of all the details and all the assets and all the relevant paperwork and bank statements and so on, then I write to all those asset holders, usually within a week to 10 days. And I need to get the balances or the values of the assets as at the date of death. That's how it's calculated. When I have all that information, I then have to prepare the Inland Revenue inheritance tax accounts. And they have to be prepared whether or not inheritance tax is payable. You always have to give an account. If inheritance tax is not payable, you submit the form to the revenue and they issue a little number. And then you send a statement, or the solicitor sends a statement to the probate registry saying, here's the tax number, here's the statement to say that we're entitled to the grant of probate, and the grant of probate would be issued within about 3 to 4 weeks. So now about overall, since the date of death, about 6 weeks to 8 weeks or 2 months has elapsed. When you get the grant of probate, you have to start circulating it amongst the asset holders. Let's say there are 5 asset holders. Right? There might be 3 accounts in one bank, a building society account, 2 accounts in another bank, some stocks and shares, and an ISA with another bank. That's pretty straightforward and pretty typical. Right? If there are 5 assets, I get 5 copies of the grant of probate. So I don't have to send it out and wait for it to come back. I just send everyone a certified copy of the grant of probate. They will then pay out, usually within about another 10 days. And then I've got all the money in. At this point, we're somewhere between 6 and 8 weeks. I pay out any debts that need to be paid, although usually they've been paid pretty early on. And then I divvy the money up in accordance with the will, send people their checks. In the meantime, of course, I've got in touch with them to get their bank details, to get their IDs, to make sure I'm sending it to the right persons. And that could therefore take 3 months. That's a typical small estate. In others, can be much more complex. If there is tax payable, the tax has to be paid in advance. Right? You've got to pay the tax before you can get the grant of probate. Now, there's ways of doing that. If there's money in the bank will issue a check directly to the revenue. So I would send the paperwork to the bank saying we've got to pay £36,000 in tax to get the grant of probate, and the bank would issue a check payable to HM Revenue and Customs. In fact, they don't even issue a check anymore. They just pay it directly into their account electronically. That's the probate. That's that paid. I get the grant of probate. I can then gather in the assets, and the tax has been prepaid. But if there's a huge amount of tax payable, you can pay it in instalments, and all the probate need is the first instalment. And if the probate involves a valuable property, then tax on the property can be spread over 6 years. You can pay it in installments over 6 years. But generally speaking, the longest probate I've ever done, I am actually still doing, and that's been running on for 3 years.
What?
But there is a dispute there with one of the charities over how the will is being interpreted. And there was a previous solicitor involved in it who the executors, the children of the deceased, were not happy with. So it came to me about 2 years ago. He'd already had a year of it. But the simplest ones, as I say, sometimes I do a grant, I do a probate, I do a gathering in of estate without getting the grant of probate. I fill in a couple of forms, send them to the bank, and the money's paid out. If it's a small amount, some banks will not regard the probate as being essential. And some of them are now releasing money up to £50,000 without seeing a grant of probate.
Okay.
They just need the forms filling in and the beneficiary of the executor to say that's all there is. So the average expected to be 3 to 4 months. In worst case scenarios, you'd be told in advance this was going to take a lot longer.
Okay. Okay. So I have a question that's sent directly through to me. I know Angela wants to come in, but you come in. This question has been there for a while. A mother has died. There are 3 adult children. Probate was applied for, unapproved. A letter of administration was sent to the sibling who applied for probate.
Yeah.
That sibling has stopped. That sibling has stopped speaking to the other 2 siblings.
Yeah.
Can the other two siblings get their own copies of the letter of administration?
Yes, you can get it from the probate registry. It's a public document.
Okay. And what does that mean then?
You just apply to the probate registry. If you go online, you'll see how to search for a grant of probate, or letters of administration suggest there was no will. There must have been no will, because a letter of administration only applies in an intestacy. But it's called a grant of representation. So you can check online when the grant was issued and who it was issued to. You can, in the rules of intestacy, they can check what they're entitled to. It doesn't say whether or not the son or the sibling who took out the power of attorney, who took out the grant of representation, has paid them any money, or he's gone quiet and without paying them any money.
All right. So if it's interstate, if the person has died interstate, as it were, does not mean that. How did that person get the right to do that as opposed to the other siblings?
Well, all three of them have the right. They should have cooperated in this. But if only one of them makes the application, they are a person entitled to make the application. The duty then passes to them under law to deal with those assets in accordance with the Administration of Estates Act, that is, to divide it out equally between himself and his siblings. If he doesn't do that, and it sounds as if he may not be going to do it, they better get their skates on and do something about it. Otherwise, the money may not be there anymore. That happened.
Okay. Okay. So, well, seems like the child that has made application is not speaking to the others, so they're going to have to get the skate on, as you say.
They're going to have to speak to him. Yeah.
Okay. So that's the end of those questions, but I know Angela had her hand up. So Angela.
Charles, my understanding is that everyone does not need to probate, and there is a certain amount that the estate has to be worth that you will have to probate. Am I correct?
Yeah, it's just as I said earlier, there's lots of banks who no longer require a grant of probate. It depends what the value of the estate is and how much money is held in any particular bank, because different banks have different levels at which they will pay out. For example, I think it's Barclays Bank will pay out up to £50,000. If there's less than £50,000 in the bank account, you can apply without the grant of probate for that money to be released to you, provided you show that you're entitled to it, show that the person is deceased, and that you promise to indemnify the bank. Going back to that question a moment ago, if the sibling who's taking the money out has run off with the money, he will have already indemnified the bank to say, I won't run off with the money, I'll give it to the person's entitled to it. But he may have run off to a place he will never be found. Or he may not have run off, he's just going to say, I'm not giving it to you, do your worst. So yes, you do not need a grant of probate for small estates, but the amount at which you do not need the grant of probate can vary depending on the banks and depending on the assets. If there is a house which is in the name of the deceased, then you will almost certainly need the grant of probate to change the register at the land registry.
Okay, so generally speaking, those small estates are property-less estates, really, rather than property estates.
Yeah, yeah. The other thing is this, it's worthwhile bearing in mind. We've talked about probate, and I mentioned earlier the letters of administration and probate. The letters of administration apply where there is no will, and they are issued under the Administration of Justice Act. And the probate is granted where there is a will. The communal name for them both is a grant of representation. You're entitled to represent the estate.
Okay. I think there's some people coming in. Did anyone else have a question for Charles since we've exhausted those questions, going back to the wills or even probate. So this is your opportunity to ask. Otherwise, we are going to try and draw this to a close. Anyone else want to? Yes.
Clive, Zarkin's still got a hand up. Was that from before?
That's from before, I believe. But so there's one. Agun Sakin, I think you did say what your first name was, but you've still got your hand up. Did you want to ask another question?
My name was Angela.
Annette.
Oh, it was Annette, was it? Annette.
Annette, yeah.
Did you want to ask another question?
I'm just thinking, when you're doing these searches, you know, you said about the probate and if there was anything else elsewhere, do you do searches abroad as well, like the West Indies?
No.
Right.
I mean, I dare say you can do them in the West Indies, but I've never done one. And I honestly don't know how, but I'm talking about the courts of England and Wales, not even the courts of Scotland, which are different. Even though I'm Scottish, I never practice law in Scotland.
You just stick around UK.
Yeah.
That's out of interest.
However, just in relation to that, though, if you've got a property abroad, do you need to bring it into? Could you separate them out and deal with the matter separately? So stuff in the Caribbean in the Caribbean, stuff in the UK in the UK.
No, you're asked to declare property abroad. They're treated differently depending what jurisdiction they're in, as to how they are taxed. But for example, I mentioned people having property in Spain, and property in France is a bigger issue in many ways. In France, you cannot leave your property to whoever you wish. It's quite different from Scotland and England and Wales. You cannot simply make your will and leave it at that. It has always been the law in France that you must leave it to family.
Okay.
So if you have French property, that is dealt with under the French legal code, which is still the Napoleonic code. Napoleon recodified all the laws of France during the Revolution and thereafter, and that all still applies. So if you left a property in France and you've purported to leave it to your friend or your partner, that won't work because the French law won't allow it.
Okay.
You still have to declare in your grant of in your inheritance tax forms, you're asked to declare properties abroad.
Okay. All right. Thanks. Drew, you wanted to come in. I'd see your hand have gone up and down at different times, but you want to come in?
Yes. Hello there. Yeah, I'm Drew. Just a very quick question. And it's kind of a complicated question, but it's to do with the fact that people nowadays, in relation to care, whereby local authorities can seek now to factor in people's assets. There are some options available for the protection of assets for people, especially when they're in a care situation now, whereby they've now got to, the local authority can pursue a value or an interest in someone's home in relation to their care circumstances. I suppose what I'm looking at is what are the protective aspects, are there options, are there around that in relation to the situation in terms of wills and trust? And forgive me if it's slightly disjointed in the way I've asked it, but
I understand. It's a question asked at least once a month, and sometimes 2 or 3 times a month. And I've been asked it only yesterday. There are steps that can be taken. The question is, as with all steps, is it a wise step to take? And the question you have to ask yourself is, what is it you're prioritizing and what is it you seek to achieve? Now, the first thing is, I have seen a pamphlet which I regard as disgraceful, issued by some outfit who've been punting it through the Daily Mail. And most of the people that come into my office say, I read in the Daily Mail or I read in the Daily Telegraph that I should be doing this to stop the local authority taking my house after I die. I find those to be scandalous and misleading. One of them actually says the local authority will inherit your estate. Well, if you excuse my French, that's just a fucking lie. And I stress it. It is a lie. And it's a pernicious lie. And it's leading people into doing things which can be very dangerous for them. The local authority will never inherit your house. The local authority will never take your house. The local authority has no interest legally in your house unless you give it to them. Now, what you're actually addressing is how are you to be funded if you need to go into residential care. Now, the simplest way of taking a step to protect against that is, this is going back to tenancies in common and joint tenants. If you are a tenant in common, you can leave your share in the house to your spouse, if you have a spouse, so that on your spouse potentially having to go into care, the surviving spouse, only own half the house, and the other half of the house is nothing to do with them. It's not legally theirs, it belongs to the children. The downside to that is it means the spouse no longer owns the house in which they live, for which they have striven and worked and saved and scrimped and brought their children up in. They no longer own the house, they only own half of it. That leaves them open to challenges potentially if their children seek to try and force the sale of the house, or if their creditors come after them for their interest in the property. Now, I don't want to overstress that because it's very unlikely to happen, but it's a common way of dealing with it. So if you're joint tenants, you say, on my death, my share of the property goes to my children, which means that the surviving spouse and the children then own the property as to 50% to the children, 50% to the surviving spouse. The downside of that also is that when it comes to it, if the surviving spouse needs to go into care, there is less money available for them to pay for that care. Therefore, they might end up in a care home that they really don't fancy very much because they can't afford any more than that. And care home fees are currently about £5,000 a month, £1,200 to £1,400 a month, depending on the care home. And therefore, the money could be quite readily used up. And if you've chosen to go in a nice home that you like, you might find you can no longer afford it and you have to move. Maybe you're so demented by then it won't matter. But you're still giving away something which is yours. Other schemes I've seen are even more complex than that and involve putting the property into trusts for children and so on. But what you're really talking about here is giving money away to try to ensure that you won't have to pay for your own care. Now, there's also a moral objection to that, at least in my eyes. If you don't pay for your care, who's going to pay for it? Can you answer that question?
Yes. What I'll say is that I think the problem we've got is, without making it too political, and I note your objection, but is that the government is, we pay national insurance, a number of things for which we're funding our care and funding services, but the government doesn't prioritize how it spends that. So what we end up doing is paying for it twice. So that would be my response to that.
Bear in mind time, Charles. I think we'll probably just there's a couple more questions that people have asked, when people have asked questions.
Going back to the legalities of it, as I've said, the one thing that you are doing is depriving yourself of an asset for which you have worked your entire life. The other thing which I've seen suggested is you give the house away to your children during your lifetime. That is disastrous. That is truly disastrous. And I'm as anxious to go home as you. I've done my dinner yet. But I will spend a moment or two on that. If you give the property away during your lifetime, then you fall foul of what used to be the Social Services Act, which is now the Work and Pensions Act. for something called deliberate. If you get pens and pieces of paper, write this down. I'm going to direct you to our website. Deliberate deprivation of assets. There's a very good website called, it's run by Age Concern. If you go online, put in your search engine, Age Concern, deliberate deprivation of assets, explains very, very cogently and simply what the effect of that can be. It is this: if you have given away your assets, and this is different from what I described earlier as one of the spouses leaving the share to the family. If you give it away to your children during your lifetime, one of the first things you're asked, should you apply for social care, is, do you own a house? You say yes or no. If you say no, next question is, did you ever own a house? Yes. Next question is, in what circumstances did you come to dispose of that house or give it to my children? Then the state will say, well, you shouldn't have done that because you have deliberately deprived yourself of assets, which means you do not qualify for care. We will not support you. And then you have left yourself potentially, or sometimes actually, destitute. And you then rely on your children to give you the money back. And let me assure you, they won't. And you will have no choice in the home that you live in because you've got no money. Then the local authority will step in and then they will say, sorry, can't help you. Speak to your family. Now, the other thing to bear in mind is this, and this is what I find so offensive about the pamphlet: the local authority will inherit your money. Most nursing homes are not run by local authorities. They're run by private people like Bupa, Beaumont, endless numbers of them. They're run by charities. They're run by private companies. They're run by various organizations which may be religious or which may be in some way favoring or seeking to favor persons from certain classes or employment and so on. Local authorities have the unwelcome burden of people come to them and saying, I don't have any money. Now, lots of people don't have any money for very valid reasons. They never earned very much. They never get a chance to put by any money to save up. They never could own a house. They are essentially people who cannot pay for their care. But what Drew's talking about is people who could pay for their care, impoverishing themselves so that they will get support from the state. It's a dangerous game to play. That's what I say. And do be wary of these schemes that you see advertised, because they're always looking to do something which is likely to explode in your face later on. And that's happened so many times. People thought they were, oh, this is a good scheme, that's a good scheme. Later on, law changes, it doesn't work. Law changes, it does exactly the opposite of what you thought it was going to do. So my advice to you would be very careful about what you're doing. And if you do go for any of these schemes, make sure that you fully understand it. Because the people that came in to see me yesterday did not understand it. They did not.
Charles, there are a few other questions, but just a follow-up now. The same doesn't apply to cash, though. So you could give away your cash, or is that the same principles?
It can apply to that as well. There is an inquiry under the Social Security or the Work and Pensions Act. The local authority, when asked for funding, are entitled to inquire as to why you need it. The thing about cash, of course, it's harder to trace, right? But again, giving away your money is a good idea if you've got plenty and you know you're never going to need it. You know you're never going to need it. And there are people in that circumstance who have, who are well heeled or get really good pensions, who think, well, I've got £100,000 here, I don't need it. Give it away. You've got tax implications there as well, but I won't go into those, and they're not all that serious. But giving away the house in which you live seems to me to be something of such magnitude that you really need to know what you're doing.
Sorry, Charles, my only observation on that, they're a danger of it is that actually the kids might throw you out of your house.
There's that possibility. And you would need to, if you were doing that scheme I mentioned earlier, you need to make sure in the will that if you wanted to, you were creating a right for the surviving spouse to continue living in the property. Even if they don't get thrown out, they can get prized out.
Yes, indeed.
Go on, Mum, you can't live here anymore, you're not managing. And that's sometimes a valid thing to say. You're doing it in the best interests of the person who's living in the house. But there's always a temptation to think, Mommy, you're using up my inheritance sitting there. Right?
Indeed. Charles, a couple of quick, a few more questions. Is there a certain amount where monies from a bank need to, before money from a bank need to go to probate? So, for example, 50,000.
I said earlier, it varies from bank to bank, but many banks, if the balances are relatively small, and I know in the case of Barclays, it's up to £50,000, that's not that small, the banks themselves will pay out, provided you go through their formalities without the grant of probate.
So does the money from the bank need to be added to the sale of the house, or can it be dealt with separately?
No, it's all part of the estate.
Okay.
It's all part of the estate. It's just, if you need to get a grant of probate, you need to declare all the assets of the estate.
Okay. And another question is, can one get money from a bank before the house is sold?
Yes, in certain circumstances. You can get money to pay tax, you can get money to pay the funeral account. That's all. The bank will issue a check directly to the undertakers, or the bank will issue a check directly to the revenue.
And I think there was another point here about, does all money in the bank need to go to probate? But I presume that if it's only cash, I presume maybe not, depending on the level. But
all money has to be accounted for.
Yes.
Right. Whether it's probate or not, because if the will says, as you were talking earlier about the chap who may have run off with the money, if the will says John's the executor, but he's got to divide it all out between his 4 siblings, that's what he must do. Whether it's probated or just money taken out of the bank, he's still bound by that will.
Okay. Absolutely. Angela, I think I don't know if your hand is still up from before, because
no. My hand is not up from before. I'm just going to say, Charles, I am so grateful that you spoke about the care and the money. And I can give you as many examples of people who have done similar things and what the outcome was. I'm so grateful, Charles, and I hope they all listened to what you said concerning care and that money.
Okay.
Thanks, Robert. And finally, Drew, is it the old hand, or did you want to come back on something? Okay.
That's the old hand.
Okay, thanks very much. So, Valerie, I think we're going to give you the last word as the last person. Valerie, I think you got your hand up.
Yeah, okay, yeah. It's a really quick one. I have a will which was done online. It was organised by a financial advisor that I had at the time. So it was all online. If I decide to leave them, do I have to notify them that if I go somewhere else, say if I came to you or what have you, would I have?
Good idea. Any new will, usually the first or second line of any will says, I declare this, I revoke all previous wills and declare this to be my last will. But it's a good idea to tidy up behind you and let the other people who are holding a will know you've now made a new will, and that's all you need to do.
Right.
Also very important, as I said earlier, to make sure that your executor and your beneficiaries know that you've made a new will and where it's to be found, whether it's in a solicitor's office or whether it's in your drawer or your box that you keep all your valuable bits of paper.
Okay, thank you.
Thank you.
Okay.
Just to say, Charles did mention the rough cost of doing a will. There are some cheaper ways of still doing it through a solicitor, such as, for example, when there's will month or...
I don't do it anymore.
You don't do it anymore?
I did it enthusiastically for about 10 years until people started coming into me with really complicated wills and giving me the absolutely minimum donation, with me having to do 4 hours work and them giving a charity £100 for £1,000 worth of work. So I've stopped doing it about 5 years ago.
I believe there are still some solicitors who do offer that service.
There are people who are much better than me.
Yeah, yes. But look, can I just take this opportunity to thank you, Charles? I've already seen some observations in the chat about how useful this your contribution has been tonight. I've certainly found it informative. I've got a will, but there are some things that I hadn't given much consideration to at all, which I will now need to think about. So thank you very much for giving up your valuable time and joining us this evening. We will no doubt keep in touch with you. You've helped us before, and we appreciate the fact that you've taken the time.
Just one more, though. You may have noticed I'm quite grey-haired.
Yes.
I might not be here in another year's time. I'll either be dead or hopefully retired.
Oh, in that case, happy retirement when it comes.
Definite. But do touch. I'll always try and help.
Yeah, but I dare say, hopefully there'll be some of your colleagues that might be as willing to do so. Can I just say to you, to all colleagues who have been here, thank you very much for joining in. This is a session that's been organized as a part of the Watford African Caribbean Association. It is your organization. Please choose to join with us because, as our motto says, together we can achieve. But Marcia wanted to have a final word as our secretary.
Okay.
No, I didn't. I was just clapping.
Oh, you're just clapping. Maybe those of us you are still here might want to put the camera. Put your camera on and give
thank you,
Charles.
It was very informative.
It was, absolutely.
Those of you who are still here, maybe you'd like to put your camera on, and we will. We won't be. Don't be shy, because I think it's been a useful session, and I'm going to stop the recording of the session now.
Thank you and good night.
Charles.